we want to bring in a news update that is coming up with regards to the F-1 visa revocation emails that people are receiving from the consulate that their visa has been revoked and the consequences to that thing. Along with me is my business partner, Emily Neumann and Stephen Brown. We are taking this matter very seriously. Now, Emily, previously also when we used to have DUI particularly, though, that's driving under the influence of alcohol in particular, that we used to get the visa revocation for F-1 visa people. Now, even if the F-1 was revoked, we used to say that, yes, you can continue going to school, you can continue doing OPT, you can continue doing STEM extension, you won't have any problem, you can get the H-1B approval. However, when you go for the stamping in their home country, then they have to go to the medical evaluation with the panel of the physicians. That is what we've been telling consistently. And now we didn't used to see the visa revocation. Mostly we used to see visa revocation only for DUI or certain major crimes. But right now, we have received the email notifications for the parking ticket violation, traffic ticket violations, where people have forgot to pay the money or people have forgot to pay the speeding ticket. And they are also issued as notice of intent to, sorry, not notice of intent to revoke, revocation of the visas. And then initially we said, oh, no, nothing is going to happen. Your SEVIS is not going to be terminated. Then it turns out right now that the SEVIS is terminated right now for them. That means that technically speaking of, they are not in lawful status because their SEVIS has been terminated. Can you explain what's going on, Emily?
Yeah, so the visa revocations is really nothing new when it comes to criminal issues in the United States. But what is new this time around for students is it seems that the Department of Homeland Security through ICE, so ICE is in charge of F-1 student visas through the SEVP program and study in the state's website, are now taking these revocations further and saying simply that because of a records check showed criminal activity, we are terminating your SEVIS record. Now, the SEVIS record is your lawful presence in the country when you're on a student visa. So to get a student visa, you apply to the school, you get an I-20 from the school that's issued by SEVP. You get the visa stamp, you come in, and as long as you keep your SEVIS record active and are taking your classes and doing all the things you're supposed to be as a student, you are considered to be maintaining F-1 status, because when you come into the US, you get not a specific end date on your I-94, because we don't know how long your program is actually going to last or how long you're actually going to stay in F-1 status. So it'll say that duration of status or D/S. So as long as you have the SEVIS record active and are going to school like you're supposed to be, you're considered to be in status. Now they're using this SEVIS termination as a way to say you are no longer in status as F-1s. And so once you fall out of status, now we have to look at what are your options to get back into status. And on top of it, the USCIS website seems to be quietly updated back in January saying that if an F-1 student is found to be out of status, unlawful presence accrues. Normally, there's no unlawful presence for F-1 students because of that duration of status, that D/S. There's no end date, so there's nothing for you to overstay. Now they're saying that because your SEVIS is terminated, you are now out of status, and once you are out of status, now you are unlawfully present, which makes it even more difficult to figure out how to navigate this situation to try to get back into status. So we were kind of talking about the different options that are available. Stephen, I don't know if you want to run through kind of our thought processes on what options are available for a student in this situation.
Yeah, so Emily, thanks. So spent a lot of time on this yesterday when we started seeing this pop up together. And look, when you're terminated with your SEVIS, I see three typical options. You can depart, right? Everybody, you always have that option. You can depart the U.S. I don't think that's the option people want to take, but it's there. Number two, you can, generally speaking, apply for reinstatement. We're going to talk about that in a minute because I don't know in this circumstance if it's the route I would take. And also, right now, what we're doing is exploring litigation options, suing on this. It's a final agency action. I do not think they have proper authority for it, but we're still digging into that, today. Emily, with reinstatement, you and I spent a lot of time talking about this yesterday. Generally speaking, when you fall out of F-1 status, let's say you're sick and you drop below hours, you failed a class, whatever it might be, you can apply for reinstatement. It's in USCIS's discretion, so weirdly a different sub-agency. You have to do it within 5 months. You have to show you're not a repeat violator of regulations, that you're going to pursue a full course of study, no unauthorized employment, and then you're not deportable for any other reason other than the SEVIS being terminated. But this is where I think it's going to be problematic. You have to show that the violation resulted from circumstances beyond the student's control. And again, when we've done reinstatements in the past, someone gets sick, they're in the hospital, they drop below hours, like that's beyond the student's control. That makes sense. Here, I think ICE is making a calculated decision for whatever reason, political, whatever. People that we view, that ICE views as criminals, are not made, we don't want them. And we're going to terminate the SEVIS. I don't know if they're going to be able to prove to another DHS sub-agency that that's beyond their control. What do you think?
Yeah, the USCIS has a policy manual where they give us guidance on how they make determinations in all the different types of immigration applications people make. And so there is a section on F-1. There's a section specifically on reinstatement. And the policy manual right now specifically says violations due to the student's actions, such as criminal activity, are not considered circumstances beyond the student's control. So in order to apply for reinstatement and be approved, you have to always prove that the violation resulted from circumstances beyond the student's control. Next paragraph, they specifically say criminal activity is not beyond the student's control. Therefore, I think, people that are being recommended to file for reinstatement, it's very unlikely to be successful because it's all based on criminal activity. Even if it's just an arrest, obviously with an arrest, there needs to be due process. It's not a conviction. So criminal activity is questionable, but an arrest is an arrest, and that's what they're basing this on. And as you mentioned, this seems to be a policy of the Department of State, of DHS. DHS is broken down into ICE, which handles F-1 student visa SEVIS, USCIS, which handles reinstatement. So although they're two separate agencies, they're under the same umbrella. And if they have determined that this is what we want to attack right now, to show the news agencies that we're being hard on crime and immigrants, then I don't think USCIS is going to make a different decision to allow these students to get back into F-1 status when ICE is the one saying these people are criminals and should not be in the United States.
Yeah, we've seen the F-1 in the news quite a bit. So, it started with kind of the protesters in Colombia, and we've seen others. So, I think they're just wanting to be tough on crime, and they're pushing it right now with these student visas.
Emily and Stephen, first of all, when we are addressing the criminals, though, only if you are being charged, unless you're not guilty, when you're charged, you're not guilty, Emily, according to the criminal law. And of course, in the immigration law, they may interpret differently, but were we not taught in the law school that when you're charged, you're not, until proven, you're not guilty? And certain things that we are getting notice of revocations of the visas, though, these people are not convicted of anything. They were being they were not convicted of any crime. Some of them were being just charged and the case has been completely dismissed. Some of them, we are speaking only parking ticket did not pay on time. Speeding ticket did not pay on time. they got the revocation. Are we speaking them as criminals too? Are we speaking them as a convicted criminals, Emily and Stephen? And of course, you said that there is one particular person that got visa revocation where that person was having an affair with underage child, which will be considered as a very major crime and must. I understand them terminating the civil system. We are speaking about traffic tickets, parking lot tickets. Are they criminals too?
Yeah. So what I
Yeah.
received, yes, what I received yesterday from a student is that their SEVIS, they were notified by the school that there was a notation that their SEVIS was terminated, quote, individual identified in a criminal records check. This individual has a couple of speeding tickets, and that's it. He had one arrest for racing, which they reduced to a speeding ticket, but nothing, not a major crime that would make them removable. You know, the one with the kid, that's a potential removability. I know you mentioned you had talked with someone with a parking ticket issue. Same thing. And I've talked to other attorneys around the nation, and it's coming up with this same identifier, individual identified in criminal records check.
So, what's the solution right now? Emily, you're saying that reinstatement probably won't work. Let me propose another principle. If they can move on to B2 visa or H4 visa or any other visa, if they are eligible for, can they move? And of course, you will say that they are out of status on the day they are filing the application because they've been terminated from the civil system. Can they use a non-protunct argument that means that, hey, I became out of status because because it was beyond my control, and now I'm filing for the H4 or any other dependent visa. Can they do that after they've been terminated from the civil system?
Yeah, so normally I would say that, whenever you're filing a change of status to any other type of visa category, you always have to show on the day that you filed it that you were properly maintaining the status that you already have. So as we discussed with the SEVIS termination, that immediately puts the student out of status. And so unless you've already filed that application before the termination happened, you will be considered to be out of status on the day of filing. But there are provisions that say that if you were out of status on the day of filing, but you can show that the delay in filing after you lost your status was due to extraordinary circumstances beyond your control, and you do not intend to be an immigrant, you have never been in deportation proceedings, the government can basically overlook that gap in status and approve the change of status, putting you back in status. We call this nunc pro tunc. So we are basically filing an application saying, we realize I'm already out of status at the time of filing, so it's considered to be late, but I'm requesting you in your discretion to overlook the late filing and put me back in status because of these extraordinary circumstances. The problem is, and we use that quite often, and it's successful quite often. The problem is it is discretionary. That means that particular USCIS officer has complete decision-making authority to approve it or denying it based on whether they think it's beyond your control, whether they think it was an extraordinary circumstance. And so just like with reinstatement, if we already have a policy saying criminal activity is not beyond the student's control, for reinstatement, I would expect that USCIS is going to be on the same page and say, well, this also was not beyond your control because you're the one that committed a crime. No, did you commit a crime? We don't know yet. You were just arrested. They're doing this based only on arrest. But so I do think that filing a change of status with a nunc pro tunc may not be successful here, and the processing time is going to be long, where you're going to be potentially accruing unlawful presence for more than 180 days while you're waiting for a decision. And for that reason, it may not be a good option.
Is litigation an option? Can we sue the ICE or the university? Stephen, you're the master for the litigation.
Yeah, I think so. It's something we're digging into. I spent a lot of time on yesterday. We're looking into more today. I don't think it's the school. Every single one of these cases that I have talked to, it is not the school terminating the SEVIS. The school is shocked. I had one yesterday who the school said it was, quote, unprecedented. I reached out to a DSO that I know who said, we don't know what this is about. I don't think it's the school. I think it's ICE. And that's who we would be suing. And I've actually, by the way, know of schools that are reaching out to attorneys that are trying to protect their students as well, because it's just happening and nobody's getting a chance to rebut it. It's just terminating the SEVIS. It's just done, happened.
So if I'm being terminated from service system, if somebody were to sue the ICE, Immigration and Customs Enforcement, what is the process involved in it?
Yeah, well, that's part of what we're exploring. I mean, I do think what makes these different than most lawsuits is we have to move quick because there's unlawful presence issues, because there's risks of, again, we're watching the news and removability, right? They've determined you're a criminal, you're out of status, you're unlawfully present, you're now an illegal alien, and, they can remove you. The current strategy we're thinking through is filing a lawsuit with, some emergency motions to get this heard quickly. And I just think you have to, when you look at reinstatement, saying criminal records aren't grounds for reinstatement. Okay, maybe we do nunc pro tunc and risk 180 days of unlawful presence, and let them use their discretion, or we try to fight this out in the courts, and we're building that kind of today as this progresses, because this is something we started seeing yesterday. Was it yesterday? Yesterday. I know it started in the last week, and we're kind of hitting the ground running because this is a big deal.
So you have any case that you're about to file, Stephen? Can you give a little bit more details?
I am hopeful. I am filing a case Friday.
Tomorrow.
Yeah, I guess that's tomorrow. Yes, I am hopeful. I'm waiting on just.
And on what grounds are you against you? Of course, you said the defendant will be ICE, but what grounds?
Yeah, so couple thoughts. I mean, I think you have some Administrative Procedure Act issues within terms of notice. I think you have regulatory and statutory issues. On first glance at research, I'm not convinced ICE has the authority to terminate SEVIS for this reason. There's some pretty clear guidelines on when SEVIS can be terminated, and I don't know if this is one of them. And actually, I thought I found something yesterday that would give them that authority, but it requires notice within the Federal Register saying, you're a public danger. I think maybe they're going to try to interpret that a little bit differently. So we'll see. I mean, this is a developing thing. This isn't like our delay cases where I kind of know this is how it's going to go. Exactly. This is kind of new and uncharted territory, but I think we've got the right mindset working on this right now, and I think it's a good strong case.
I'm thinking this way, that can we do the to reinstate from the request from the DSO to ICE to reinstate the person, and second is to file a non-protunc if they have H4 options or any other non-immigrant options, if not a B2 non-protunc application. And court litigation, can we do all three at the same time? Do you see any fault in it?
I don't see any problem with that. So with the filing of a change of status, that does not automatically end your F-1 status. You can continue your current status until you get a decision on that. And then filing the reinstatement request, it is one of the options available. I don't see it impacting your ability to file a change of status. And then with the litigation, I think that that's probably the route that we're going to have to take until we get ICE to change its policy or change its procedure here.
Just one small caveat. I think we will have an issue if there's a reinstatement pending before we file the lawsuit. Because if you filed reinstatement, I think you're kind of going through your administrative appeal. And so there's not a true final agency action. But there is nothing. And one thing, I talked with someone about this morning is, what if we file the lawsuit? We see how the motion goes. That's not going to preclude you, from filing reinstatement during that 5 months. So if we want to say, hey, let's file a lawsuit, if it's successful, great. If not, we can still do reinstatement, or, hey, maybe 3 weeks, 4 weeks in, we can file reinstatement as a backup. Again, I have low expectations on reinstatement, kind of given this is a political decision, but I think you got to file the lawsuit and then reinstatement. Just really weird procedural court side of things.
One of the things I'm planning to do right now, Emily, I think so, is that, hey, why not request the DSO will request for the data correction? Remember when we have somebody, civil system is terminated because the H-1B has been approved. Actually, it was approved in consular processing. And then we go to DSO, hey, DSO, my H-1B is approved in the consular processing. Why don't you approach the ICE to tell them, hey, his H-1B is approved in the consular processing, so SEVIS should not have been terminated, and then normally put the civil system back. That's called data correction. That can be done so easily. Can we do that with the DSO right now?
I mean, the DSO can ask, but it's ICE's decision whether to actually allow the data fix or not. And considering that ICE is the one that is terminating the SEVIS and it's due to an arrest, I think it's unlikely that they're going to just, oh, never mind. We changed our mind. We'll let you back in. I don't see that happening, but I don't see any problem with a DSO asking.
So let's
it's totally fair to try all your options there. But again, I think you're right, Emily. I think we're talking about, there is a policy that has been decided way above the DSOs and all that. I mean, I think this is probably a cabinet level decision that has been made. I don't think they're going to overturn their own decision.
So right now,
Maybe I'm wrong.
right now, this is what I'm thinking, Emily. If I'm a student and I've been terminated from civil system, I'm going to first request the DSO to do the data correction, which normally takes 2-3 days to get response from ICE, or maybe at the most 1 week. I will also file a non-protunct change of status to other status. If there is no H4 or other options, definitely B2 is one option to apply into non-protunct B2 change of status. Then I'm thinking of course, going through the litigation process, because if I do the reinstatement, though, Stephen, because once we apply the reinstatement, we are requesting the USCIS saying that please reinstate, then we are going to the court to do the same thing. So the court may say that, hey, why don't the USCIS make a decision? Then we'll make a decision. So I'm thinking of doing data correction, change of status to different status, and going through litigation process. This is what I'm thinking.
Yeah.
Yeah, and with the change of status, because it does take time to be processed, if the litigation is ultimately successful, you should have time to withdraw the change of status request to be able to continue your F-1 status. So I think that's just kind of a backup plan based on processing time, so that you've got multiple options in case the litigation doesn't work.
One of the other thing that I want to discuss is that this is only for F-1 visas, what we're discussing all along. We got a question from Adit. This is not for the people who are on H-1B or H-4, because even though their visa may be revoked because of the DUI, for the people to get the H-1B people or other non-immigrant visa people like H-4, L-1, L-2 people, when the USCIS want to revoke their H-1B, though, they send a notice of intent to revoke, and then they will revoke it. For F-1 visa people, there is the SEVIS just suspending. Initially, we thought that SEVIS will not be terminated, so SEVIS will still be. But of course, we started hearing that SEVIS is getting terminated right now. For the H-1Bs, if the visa has been revoked, they can still stay, they can still work in United States unless their H-1B is revoked. At this point of time, the process for the USCIS to revoke the H-1B is that they have to send a notice of intent to revoke, and then you will get an option to respond to it. Of course, you will have a lawyer responding to it, and then you will be they will take an action. It's not like F-1. They're taking a unilateral decision on F-1 visa. So Adit, This live question that you're coming is not applicable to you. This is only for F1 visas. Now, can that be happen with H1B also, Emily? Like, can the H1B, what's the process?
I think,
But
yeah, I think the visa can absolutely be revoked because State Department can basically say at the time we issued you the visa, circumstances have changed since then. We see this criminal issue and therefore we're revoking your visa. But a visa revocation does the visa, we're talking about the stamp in your passport, which is different than your actual H-1B petition that's approved by USCIS and provides you with that work authorization. Your I-94 is still valid. It's not expired. And so I think that if Department of State is going to continue this and expand it beyond F1 to start revoking visas of H and L, USCIS has to take the next step to actually send a notice of intent to revoke, giving the company and you an opportunity to respond. So there should still be options in that situation. I don't know if maybe they're starting with F1s because they don't have to do a notice of intent to revoke, because they can just terminate the SEVIS and that puts you out of status. Because F1s are students, they might not have the money and the connections. There's no employer involved to litigate this or to fight back. That seems to be kind of in their mind an easy way to get some wins on their policy agenda of, trying to kick out people who have criminal issues, which again, an arrest does not mean you are guilty, innocent until proven guilty. And they are doing this based from what we can see on an arrest itself, or even, as you mentioned, parking tickets and speeding tickets. So
yeah, and I mean,
we'll see if
I
it
think
gets
I saw.
expanded.
Well, I think I saw one yesterday. I know we had a question on this where they got a ticket. They were in a car accident. So, sometimes if you get into a car accident, you get a ticket for failing to control speed, failing to yield, whatever it is. I think we saw one like that too. So, I mean, it's very minor things. These aren't, I've had speeding tickets before. I don't think I should be removed.
yeah, speeding tickets and parking tickets are what we're discussing here. Anything else, Emily?
Oh, just stay tuned. I mean, this is going to be a, fluid situation based on how students are responding, based on how schools are responding. And we'll see if ICE makes any changes or if they expand it further, or if Department of State expands it further into other visa categories. So just stay tuned is the most important thing.
And of course, if there is any litigation update also, we are going to update about it. So we do have this live sessions going on every Tuesday, but if there is anything that pops up, we will give an update in the YouTube. And you can also subscribe to our newsletter at rnlawgroup.com. We do have a daily Zoom conference call. You guys can attend it, and the link is provided at the bottom. And if some people have not received any visa revocation, they are in worry that will they receive any visa revocation because of any arrest or parking or anything, any violations. I've put a link there at the bottom where you can check if your visa has been revoked or not. It's an official site of the Department of State. The link is provided to you at the bottom of this video. You can go there and check if your visa has been revoked. Anything else, Steven?
No, just like you said, stay tuned. We're gonna be. This is gonna be developing.
Thank you guys for coming.